I have sat in enough courtrooms to know that justice is not a place. It is not a building with columns out front and a flag on the roof and a seal carved into the stone above the door.
It is not a robe hanging on a hook behind a bench, or a gavel, or a stack of files with case numbers printed on the tabs. I have known that since I was 24 years old and walked into my first real courtroom as a licensed attorney in the state of Texas, nervous, underpaid, carrying a briefcase that was too big for me, representing a family who had been told by everyone they consulted that they had already lost before they started. We won that case, not because the system was designed to help us win, not because the room was built for people who looked like us. We won because the facts were unbreakable, and because I had spent 3 months making sure that every person in that room understood exactly what the facts were. I have been doing that for 22 years. I am 46 years old. I am a civil rights attorney licensed in Texas, Louisiana, and the federal courts of the Fifth Circuit. I spent 8 years before that serving 2 full terms as a member of the Texas House of Representatives, where I sat on the Judiciary Committee and helped write the language for 3 pieces of legislation that are still on the books today. I have been deposed, cross-examined, cited, appealed, and overturned. I have won cases that no one thought I could win, and I have lost cases that I should have won, and I have learned something valuable from every single one of them. I drive a practical car. I wear sensible shoes when I know I am going to be on my feet all day. I keep a photograph of my grandmother on the corner of my desk because she was the one who told me when I was 8 years old and had just discovered that certain doors were closed to certain people, that the answer to a closed door was never to stand outside feeling sorry about it. The answer, she said, was to learn exactly how locks work. I have been learning how locks work ever since. But this story, the one I am about to tell you, this is not a story about a courtroom. Or rather, it is not only a story about a courtroom. It begins before that, on a Tuesday morning in March at 7:51 at the intersection of Lancaster Avenue and Hemphill Street in Fort Worth, Texas, when I was 23 minutes away from one of the most significant hearings of my career, and a set of flashing lights appeared in my rearview mirror for no reason that I had given anyone. I want to tell you this story from the beginning, and I want to tell it to you exactly as it happened because I think if I skip any part of it, you will miss the thing that matters most. And the thing that matters most is not the ending. Though the ending will stay with you, I promise you that. The thing that matters most is what happens between the beginning and the end. The thing that matters most is what people reveal about themselves when they believe they are in complete control of a situation. I was driving my silver Buick LaCrosse, not a luxury car, not a statement, just a well-maintained vehicle that got me where I needed to go, and I was running through the sequence of arguments in my head the way I always do on the way to a hearing. Not rehearsing exactly. More like tuning. The way a musician runs scales before a performance, not because they have forgotten how to play, but because the body needs to remember what the mind already knows. The radio was off. My coffee was in the cup holder, still warm. The morning light was that particular shade of pale gold that Fort Worth gets in early March, when winter has not quite made up its mind whether to let go. And the sky has a clarity to it that makes everything look more permanent than it is. I stopped at the red light on Lancaster and Hemphill. Complete stop, both hands on the wheel, behind the white line. I sat there watching the cross traffic clear, and I was thinking about a deposition I had taken the previous Thursday, a document with a timestamp that I believed was the single most important piece of evidence in the case I was about to argue. When I saw the blue and red lights flicker to life in my mirror, I took one slow breath through my nose and let it out through my mouth. Anyone who has never had to think about what that breath means will not understand why I am describing it. But anyone who has been pulled over in America while black will understand it immediately, and they will understand it in a place that is deeper than words. I pulled to the right side of Lancaster Avenue and put the car in park. I placed both hands on the steering wheel at 10 and 2. I did not reach for anything. I waited. The officer who approached was young. I would have guessed 28, maybe 30. He was tall, broad-shouldered, with a neat dark buzz cut under his hat, and the kind of posture that comes from believing, genuinely, and without much reflection, that authority is a natural feature of the landscape rather than something that has to be earned. His nameplate said T. Mercer. He walked up to the driver's side window with one hand resting on his belt and his eyes already moving over the interior of my car before he had said a single word to me. "License and registration," he said.
No greeting. No explanation.
"Of course," I said. I kept my voice easy, unhurried. I moved my right hand slowly toward the glove compartment, keeping my left hand visible on the wheel, and I retrieved the documents the way I have retrieved them 100 times in my life. Deliberately, transparently, making sure that every movement I made was legible to the person watching me. He took the license and looked at it. Then he looked at me. Then he looked at the car. Then he looked at me again, and there was something in that second look, a particular quality of reassessment, like a man who had arrived at a conclusion before he started, and was mildly irritated to find that the evidence was not cooperating. That told me more about what the stop was than anything he had yet said. "Where are you coming from this morning?" he asked. "My home," I said. "I am on my way to a hearing." "A hearing?" He said it the way people repeat a word when they have heard it, but are not yet sure they believe it. "Yes," I said. "At the Tarrant County Civil Courthouse. I have an appointment at 9 o'clock. He looked at my registration. He looked at my insurance card. He handed them back to me without comment and then stood there for a moment, not returning to his vehicle, not explaining why he had pulled me over, just standing there with one hand on the roof of my car and his eyes moving around the interior with the casual thoroughness of someone conducting a search they have not yet been asked permission to conduct. "You don't live around here," he said. It was not a question. "My address is on a license," I said. "Ridgely Hills. I have lived there for 11 years. He nodded slowly, the nod of a man who has received information and has chosen not to update his opinion based on it. "You ran the yellow light back there," he said. I turned to look at him directly. "Officer Mercer," I said. The light turned yellow as I entered the intersection. I was already committed to the crossing. That is not a traffic violation under Texas law. Something shifted in his jaw, not quite tightening, more like a settling, the look of a man who has just registered that the person he is speaking to is not going to be as easy to manage as he had assumed. "I see things a little differently," he said. "That is your right," I said. "But I would like to understand the specific violation you are citing because I do have somewhere I need to be." He did not answer that. Instead, he said, "Can you step out of the vehicle for me?" I looked at him for a moment, not to challenge him. I looked at him the way I look at a witness who has just said something unexpected on the stand. Carefully, thoroughly, trying to understand exactly what I am dealing with and what is likely to come next. "For what reason?" I asked. "Standard procedure," he said. "I would appreciate a more specific explanation," I said, "before I step out of a vehicle on a public street without understanding the legal basis for the request."
His posture changed.
It was subtle, a small forward shift, a change in the angle of his shoulders, and I recognized it immediately as the posture of a man who is accustomed to people doing what he says and is recalibrating for the fact that he has encountered someone who is not going to. "Ma'am," he said, and the word had an edge to it now, "I am asking you to step out of the vehicle. That is a lawful order from a law enforcement officer." I reached carefully to the center console, took my phone, and opened the voice recording application. I held it up so he could see exactly what I was doing. "Under Texas Penal Code," I said, "I am legally permitted to record this interaction. I want you to know that I am doing so." He looked at the phone. He looked at me. For a moment, something passed across his face. Not quite hesitation, not quite doubt, but something adjacent to both of them. I stepped out of the car. I stood on the sidewalk on Lancaster Avenue in my charcoal gray blazer and my flat black shoes with my briefcase still on the passenger seat and the morning traffic moving past us on both sides. And I stood straight because I have learned a long time ago that how you hold your body in a difficult moment communicates something to every person watching, including yourself. He looked me over. I have been looked over like that more times than I can count, and I have never found a way to make it feel like something other than what it is. A person deciding in the space of a few seconds what category you belong to based on information they acquired before they ever asked you a question. "Where exactly do you work?" he asked. "I am a civil rights attorney," I said. "I have been licensed to practice in Texas for 22 years. He made a small sound that was not quite a laugh. "Civil rights attorney," he said, the same way he had repeated hearing, with that thin layer of skepticism that certain people apply to statements they find implausible. "Yes," I said. "And I also served 2 terms in the Texas House of Representatives, representing the district that includes this part of Fort Worth, which means I am also familiar with the statutory framework that governs traffic stops in the state. So I am going to ask you one more time, Officer Mercer, clearly and on the record, what specific violation are you citing as the basis for the stop?" He was quiet for a moment. Then he said, and I want you to hear these exact words, because I have replayed them in my mind many times since that morning. He said, "People like you always think the rules work different for them. People like you." I have heard those 3 words in 100 different configurations over the course of my life. I heard them when I was the only black girl in my AP chemistry class in high school. I heard them in law school in the way certain professors called on everyone else before they called on me. I heard them in the legislature in the way certain colleagues shook hands with everyone at the table and then looked slightly past me, as though I were a projection rather than a person. "People like you" is a sentence that certain people have been using for a very long time to mean something they have decided they can no longer say directly. And every time I hear it, I make a choice about how to respond. That choice has never been easy, and it has never been the same twice, and it has never stopped being a choice that I resent having to make. That morning on Lancaster Avenue, I made it very carefully. I opened my briefcase, slowly, with full visibility. I removed a single document, a letter on official Texas Supreme Court stationery, bearing the court seal and the signature of Chief Justice Renata Holloway, and I placed it on the hood of my car, where Officer Mercer could read it without me having to hand it to him. He leaned forward and read it. I watched his face the way I watch a jury when opposing counsel makes their closing argument, looking for the moment when the information lands, when the frame of the situation shifts, when a person who is certain of something begins to understand that their certainty was built on ground that is no longer holding. The letter stated that I had been appointed as a temporary presiding judge for a civil hearing at Tarrant County Civil District Court, authorized under emergency judicial assignment provisions, effective beginning that morning at 9 o'clock. It bore my name, my bar number, my legislative service record, and the name of the Chief Justice who had signed it. He read it twice. I saw his eyes go to the beginning and start again. Then he straightened up and looked at me, and the look on his face was something I do not want to describe as satisfying, because satisfaction was not the emotion I was feeling. What I was feeling was something more complicated and more tired than satisfaction. I was feeling the particular exhaustion of a person who has had to prove themselves again, in a situation where they should not have had to prove anything. At an hour when they had too many other things to do to be standing on a sidewalk justifying their existence to someone who had decided before he turned on his lights what kind of person he was dealing with. I picked the letter up and returned it to my briefcase. "Officer Mercer," I said, "I am not going to file a formal complaint this morning. I want to be clear about why. It is not because I think what happened here is acceptable. It is not because I do not believe a complaint would be warranted. It is because I have a hearing that starts in 41 minutes on behalf of a young man whose future depends on what I do in that room today, and he has been waiting long enough for someone in the system to take his situation seriously. His need is more urgent than my frustration right now. But I want you to sit with something for the rest of your shift today. I had that letter. I had a recording. I had 22 years and a legislative record and a bar number and a Supreme Court appointment. Most people you stop in the city when you decide that their face or their car or their neighborhood does not match the picture in your head, most of those people do not have any of that. And they have the same rights I have. They deserve the same treatment, not because of what they carry or what they have achieved or who they know, because of who they are, because they are people, And that, Officer Mercer, is the thing that a badge is supposed to protect, not the thing it is supposed to override. He said nothing. He looked at the ground for a moment, and then he looked up, and there was something in his face that was not defensiveness anymore. I could not have named it exactly. I can only say that it was different from what had been there before. I got back in my car. I pulled back onto Lancaster Avenue. I arrived at the Tarrant County Civil Courthouse at 8:53, which gave me 7 minutes to find a parking space, walk through security, take the elevator to the 4th floor, and set up my materials before the bailiff called the room to order. I made it with 3 minutes to spare. I need to tell you about the case before I tell you what happened in that courtroom, because the case is the reason everything else matters. Without understanding what was at stake and for whom, the events of the hearing that morning are just a story about lawyers arguing. With that understanding, they become something else, something that I hope, if you sit with it long enough, will stay with you the way it has stayed with me. The case was called Crestwood Property Holdings versus Andre Simmons. Andre Simmons was 23 years old. He was a junior at Tarrant County College, studying architectural drafting. He worked 2 jobs, Tuesday and Thursday evenings at a print shop on Camp Bowie Boulevard, and Saturday mornings helping his uncle with a small landscaping business to pay for his classes and his rent. He had never been arrested. He had never had a parking ticket. He had, by all observable evidence, been doing exactly what a young man in his position was supposed to do, working hard, keeping his head down, building towards something. 8 months before this hearing, Andre had signed a 1-year lease on a 1-bedroom apartment at Crestwood Commons, a mid-sized residential complex in the eastern part of Fort Worth managed by Crestwood Property Holdings, a real estate management company with properties across 6 Texas counties. He paid a security deposit and his first month's rent up front. He paid every subsequent month on time, by electronic transfer, with receipts saved in a folder on his phone because his mother had taught him to keep records of everything. He was a careful young man. He was the kind of careful that certain young people in this country learn to be not out of neurosis but out of necessity because they understand early that the margin for error available to them is narrower than the margin available to others. And they have adjusted accordingly. In the 7th month of his lease, Andre came home from his Tuesday evening shift at the print shop to find that the key fob for his building's front entrance no longer worked. He tried it 4 times. He called the after-hours maintenance line. No one answered. He sat on the front steps of his building for 2 hours, waiting, before a neighbor who recognized him let him inside. He went to his apartment door. His key did not work there either. His lock had been changed. Pushed against the wall beside his door were 3 large cardboard boxes. His clothing, his textbooks, his laptop, his drafting supplies, a small framed photograph of his mother and his late father at a Thanksgiving dinner from years ago, packed and sealed with tape that said storage on the side in blue letters. There was a notice taped to his door. It informed him that his lease had been terminated under Section 9 of his rental agreement due to repeated violation of community noise standards. It was signed by the property manager and dated 3 days prior. Andre had never received any written warning about noise. He had never received a verbal warning about noise. He had never, to his knowledge, been the subject of a noise complaint. He lived alone. He worked evenings. He went to class during the day. The neighbors on both sides of him, people he saw regularly in the hallway, had never mentioned anything to him about noise. He called the management office the next morning. He was told that the violations had been documented and the termination was final. When he asked to see the documentation, he was told it was internal and not available for tenant review. When he asked what his options were, he was told he could vacate the premises within 48 hours or the company would pursue legal action. He called his mother. Dorothy Simmons was 55 years old. She had spent 31 years teaching 3rd grade at Willowbrook Elementary School in the Polytechnic Heights neighborhood of Fort Worth. She was the kind of teacher that parents request by name and that other teachers ask for advice. The kind who still sends cards to former students on their high school graduation days. The kind who keeps photographs on her desk of every class she has ever taught because she believes. She has always believed that every child who passes through her room is worth remembering. She was also a woman who had raised Andre largely on her own after his father passed when Andre was 11, and who had done so with a combination of love and practical wisdom that had produced in her son exactly the kind of young man she had hoped to raise. When Andre called her that night from the hallway of his building, sitting on the floor with his boxes beside him because he did not know what else to do, Dorothy Simmons did not panic. She said to him, "Baby, listen to me. You keep every piece of paper they give you. You write down every conversation you have with anyone at that company, with the date and the time. And tomorrow morning I am going to call someone who knows how these things work." The person she called was a case manager at the Fort Worth Legal Aid Office, who referred her to the Texas Fair Housing Coalition, who reviewed the situation and identified it as a potential pattern case, because Andre Simmons was not the only person this had happened to at Crestwood Commons. In the previous 22 months, Crestwood Property Holdings had terminated the leases of 14 tenants at that complex, citing noise violations, lease payment issues, and unauthorized occupants. Of those 14 tenants, 11 were Black or Latino. In the same period, Crestwood had renewed the leases of every single white tenant at the property who had requested renewal, including 3 who had documented noise complaints filed against them by neighbors. When the coalition brought this pattern to Crestwood's attention and requested a meeting to discuss a resolution, Crestwood responded by filing suit against Andre Simmons for unlawful holdover tenancy and seeking damages of $22,000, an amount that was clearly designed not to reflect any actual loss, but to create a financial threat large enough to make a 23-year-old college student working 2 jobs decide that fighting back was not worth it. Crestwood had miscalculated. Andre did not decide it was not worth it, and neither did his mother. And neither did the Texas Fair Housing Coalition, which partnered with my firm to represent Andre on a contingency basis, meaning we would not be paid unless we won, which is the only way that people like Andre ever get access to the kind of legal representation that the Crestwood Property Holdings of the world take entirely for granted. I had been working on Andre Simmons's case for 4 months. I had read every document Crestwood had produced in discovery. I had deposed their property manager, their regional director, and 3 members of their compliance team. I had spent a full Saturday afternoon sitting at my dining room table with a spreadsheet and a highlighter, mapping the termination patterns across all 6 counties where Crestwood operated. And what I found when I was done, what the data showed with a clarity that no reasonable person could explain away, was a company that had developed, over a period of at least 5 years, a systematic practice of using technical lease violations as a mechanism to remove tenants of color from properties that were being repositioned for higher-income residents. They were not doing this clumsily. They were doing it with the practiced efficiency of people who had learned exactly how much documentation they needed to create the appearance of legitimacy, and exactly how far below the threshold of obvious discrimination they needed to stay to. Make litigation expensive and exhausting for anyone who tried to challenge them. The Fair Housing Act of 1968, passed in the final days after Martin Luther King Jr. was killed, and this country was forced, again, to confront what it was doing to people it claimed to value equally. That law says clearly that discriminatory housing practices are illegal whether they are overt or covert, whether the discrimination is intentional or the product of policies that have discriminatory effects. What Crestwood was doing violated that law. I was certain of it. The question was whether I could prove it in a way that the court would act on, and whether the judge assigned to the case would understand what she was looking at. I had been told 2 days before the hearing that the regularly assigned judge had a medical situation and that a temporary replacement had been appointed by the Texas Supreme Court. I had looked up the temporary judge's name and record. I had felt, for the first time in weeks, something approaching confidence. That temporary judge was me. Sterling Calloway walked into Courtroom 4 of the Tarrant County Civil Courthouse at 5 minutes to 9 wearing a suit that announced its own cost before he had crossed the threshold. He was 41 years old, a partner at the firm of Calloway, Brent, and Associates on Main Street in downtown Fort Worth, the same firm his father, former state Senator George Calloway, had helped establish 30 years ago, and whose name still opened certain doors in Tarrant County that other names could not. Sterling had been practicing law for 16 years. He had a reputation for knowing how to work a room, which is a quality that can mean many different things depending on the room, and depending on whether the person doing the working is genuinely skilled or simply accustomed to a certain kind of room working in his favor by default. He entered with his associate, a young man in a blue tie who was carrying 2 leather portfolios and the slightly harried expression of someone who had been awake since 5 in the morning reviewing documents. And he stood near the center of the room, scanning it with the easy, proprietary gaze of a man who expected to feel at home wherever he was placed. His eyes moved over the gallery, over the table where my co-counsel Janet Morrow was already seated, over the clerk's station, and then up to the bench. The bench, at that moment, was empty. I had not yet come out from the anteroom. He said something to his associate in a low voice and then turned toward the clerk, a man named Robert Hensley, who had been the senior clerk in Courtroom Four for 23 years and had the measured, seen everything demeanor of someone who has watched a great deal of human behavior and has long since stopped being surprised by any of it. Sterling looked at Robert Hensley and said, with the light conversational authority of a man who is accustomed to support staff accommodating him, "Has the replacement judge been briefed on the Crestwood file? I want to make sure we're not spending the first hour catching someone up to speed." Robert Hensley looked at Sterling Calloway with the expression of a man who is making a choice. Then he looked at his desk. "I expect court will be called to order shortly," he said. At that moment I came through the door from the anteroom, carrying my legal pad and my reading glasses, and I walked to the bench and sat down. I arranged my materials. I uncapped my pen. I looked out at the room. Sterling Calloway was standing approximately 8 feet in front of the bench, and he was looking at me with an expression that was working very hard to remain neutral. I have seen that expression before. It is the expression of a man who has made a rapid internal adjustment and is recalibrating his strategy in real time, and who does not want the recalibration to be visible. It was visible.
Good morning, I said.
This is the matter of Crestwood Property Holdings versus Andre Simmons, case number 2023-1147. I am the appointed presiding judge. Counsel, please state your appearances for the record. Sterling Calloway said his name and his firm's name. Janet Morrow said hers. The court reporter was ready. Robert Hensley had already called the case. Mr. Calloway, I said, since Crestwood is the plaintiff, you will open first. He stood, buttoned his jacket with the automatic confidence of a man who has performed this gesture thousands of times, and began. He was polished. I want to say that clearly because I believe in being honest about the people I have faced across a room, even when I have disagreed profoundly with what they were doing. Sterling Calloway was a skilled attorney. He organized his argument with precision. He moved through the lease agreement, the documented violation notices, the timeline of communications, and the company's remediation process with the fluency of someone who had prepared extensively and who understood how to present a complex paper trail as a simple narrative. Tenant violated lease. Company followed procedure. Tenant refused to vacate. Company has a right to damages. Clean, organized, reasonable sounding. He did not mention race. He did not mention demographics. He did not mention patterns. He presented the case as if it existed in a vacuum, as if Andre Simmons were simply one tenant who had violated one lease at one property, and as if Crestwood Property Holdings were simply one company enforcing one contract. That is the architecture of a certain kind of injustice. It looks exactly like compliance until you take the walls apart and look at what is holding them up. When Janet finished her opening, laying out the demographic data, with the deliberate, unhurried clarity of someone who knows that numbers told correctly need no embellishment, I saw something shift in Sterling Calloway's posture. Not alarm, more like the slight adjustment of a chess player who has noticed that the board is not quite configured the way they expected. The testimony portion of the hearing began with Crestwood's property manager, a man named Gary Weston who had been managing Crestwood Commons for 3 years and who answered questions in the precise, clipped manner of someone who has been coached extensively in what to say and, more importantly, in what not to say. He confirmed the violation documentation. He confirmed the notification process. He confirmed the timeline. He was careful and consistent, and he did not volunteer a single word beyond what he had been asked. Janet cross-examined him on the demographic breakdown of non-renewal decisions. He said he was not aware of any pattern. She presented him with the spreadsheet. He said he could not speak to properties other than the one he managed. She asked him specifically about Crestwood Commons. He said that lease decisions were made on a case-by-case basis, based on documented violations. She asked him to explain why, over a period of 22 months, 11 of the 14 lease terminations at Crestwood Commons involved tenants of color, while 0 of the lease renewals in the same period were declined for white tenants. He said he was not in a position to speculate about statistical patterns. I made a note on my legal pad. Then Janet called Andre Simmons's mother to the stand. Dorothy Simmons walked to the witness box in a gray cardigan and a blue skirt, her reading glasses pushed up on her forehead, her hands folded in front of her. She sat down with the unhurried self-possession of a woman who has spent 31 years managing rooms full of 8-year-olds and is therefore genuinely unintimidated by any other kind of room. Janet asked her to describe what happened the night Andre called her. Dorothy Simmons described it. She described the drive across town at 10:30 at night, the parking lot of the complex, her son sitting on the floor of the hallway with his back against the wall and his boxes beside him and his lease agreement in his hands. She described his face when she came through the door. She said, "He looked at me the way he looked at me when he was 11 years old and his father died. Not crying, not angry, just trying to understand something that didn't make any sense." She paused. The courtroom was quiet. He held up that lease and he said to me, "Mama, I did everything they asked. I paid every month. I never had a party. I was never loud. I kept the place clean. I did everything right." And I looked at that boy and I looked at those boxes and I thought, I've spent 31 years teaching children that if they work hard and follow the rules and treat people right, this country will treat them right back. I looked at my son on that floor, and I did not know how to tell him that I might have been wrong. She stopped. Nobody in the room made a sound. I looked at Andre Simmons, who was sitting in the gallery in a button-down shirt that was pressed with the kind of care that tells you someone ironed it with attention and meaning, not just efficiency. He was sitting very still, in the way that I have seen many young black men sit in courtrooms, contained, careful, making themselves as neutral and legible as possible because they have learned that any other way of sitting can be misread. He was looking at his mother on the stand with an expression that I recognized from the deepest part of my experience as a human being, not just as a lawyer, and I allowed myself one full moment to feel it before I returned to the work. Sterling Calloway's cross-examination of Dorothy Simmons was measured and professional, and it was also, I thought, a tactical error. He challenged her characterization of her son's tenancy, asked whether she had personal knowledge of his daily schedule, questioned whether she could independently verify that no noise complaints had been made. Dorothy Simmons answered every question with the patient precision of a woman who had been grading papers and answering parents' questions for 3 decades and was very well acquainted with the difference between a genuine inquiry and a question designed to create confusion. She did not falter. She did not become emotional in a way that muddied her testimony. She was clear and she was honest, and she was devastating in the way that simple truth is devastating when it is placed beside a complicated structure that is designed to obscure it. When she stepped down, I called a short recess. In the 10 minutes I sat in the anteroom, I reviewed the argument I was planning to make when I addressed the evidentiary questions. I also thought about the morning, about Lancaster Avenue, about Officer Mercer, about people like you. I thought about the fact that there is a version of the system, the intended version, the version that the words of the law actually describe, that is supposed to work for everyone. And I thought about the distance between that version and the version that most people encounter when they actually try to use it. Closing that distance, or at least measuring it accurately, is what I have spent my career doing. Some mornings it feels like tilting at structures that are too large to move. Other mornings it feels like exactly the right thing to do with a life. I went back into the courtroom. The afternoon session was where the case turned. Sterling Calloway submitted his final brief on the question of discriminatory intent, and in doing so, He cited a federal appeals court decision, Gordon versus Riverside Equity Management, out of the Eighth Circuit, decided in 2019 for the proposition that statistical patterns alone, without documented evidence of discriminatory intent at the decision-making level, were insufficient to support a Fair Housing Act claim. I took off my reading glasses. I set them on the bench in front of me. I looked at Sterling Calloway. "Counsel," I said, "are you citing Gordon v. Riverside Equity Management as controlling authority in this matter?" "Yes, Your Honor," he said, with the easy confidence of a man who expected the citation to land cleanly. "The Eighth Circuit decision?" I said. "Decided April 14th, 2019, authored by Judge Patricia Drummond?" He paused for just a fraction of a second. "The fraction of a second that tells you everything." "That's correct," he said. "Mr. Calloway," I said, "I am familiar with that decision. I am familiar with it because the Texas Fair Housing Coalition submitted an amicus brief in a subsequent en-banc review, and because the en-banc panel issued a clarifying opinion in August of 2020 that significantly narrowed the original holding. The clarification, which is in footnote 12 of the August opinion, page 47, explicitly states that the statistical pattern exception applies in the Fifth Circuit, which is the circuit in which this court sits, and specifically excludes the application of the original Gordon holding in cases involving multi-property management companies operating in federally designated protected housing markets. Tarrant County has been a designated protected housing market since 2017. So I am going to ask you directly on the record, are you representing to this court that the unmodified Gordon holding applies to the facts before us, having reviewed the 2020 en-banc clarification? The silence that followed was not long in terms of clock time. It was long in every other sense. Sterling Calloway looked at his associate. His associate was typing rapidly on a laptop with the urgency of a person who already knows what they are about to find. "Your Honor," Calloway said, "I may need a brief moment to. The record will reflect," I said, "that plaintiff's counsel has cited a federal precedent for which a subsequent clarifying opinion exists in the controlling circuit without acknowledgement of that clarification. We will recess for 20 minutes. During that time, I expect plaintiff's counsel to review the 2020 Gordon en-banc opinion and to be prepared to tell this court whether they are withdrawing or modifying the citation." I stood. The bailiff called the room. In the hall during the recess, Janet found me near the water fountain. She said nothing for a moment. Then she said, "He really thought he was going to walk in here and run the same play he always runs." "Yes," I said. "How did he not know you'd have read every word of that brief?" "Because," I said, "he looked at this room and he saw what he expected to see. That is an error I have watched people make my entire career. It does not make it less remarkable every time." When we reconvened, Sterling Calloway did not withdraw the citation entirely. He reframed it, narrowed it, attempted to salvage the structural argument through a different line of reasoning. It was a competent recovery, but it was a recovery and we both knew it, and more importantly, the record knew it. I had watched enough legal proceedings to know that when an attorney makes a significant evidentiary error in front of a judge who has caught it clearly and placed it on the record, the remainder of the proceeding carries that weight. Every argument that follows is measured against it. I gave both sides the opportunity to conclude their presentations. Then I addressed the room. "I want to tell you what I said because I believe the words matter." I said, "The Fair Housing Act of 1968 was not an abstraction. It was not a theoretical exercise in legislative drafting. It was a response to a specific, documented, extensively practiced set of behaviors by which certain categories of Americans were systematically prevented from living where they chose to live, from building equity in neighborhoods that were deliberately kept unavailable to them, from accessing schools and services and safety that were, by design, reserved for people who looked a certain way. That law was written to be enforceable. It was written with the understanding that discrimination is rarely a single document with a smoking gun at the center of it. It is almost always a pattern. It is a series of decisions that each look reasonable in isolation and that reveal their nature only when you look at all of them together, over time, across cases, across properties, across the populations of people they consistently affect. What the evidence in this case shows, the demographic data, the termination patterns, the documented disparity in how the same company applied the same standards to different categories of tenants, is exactly the kind of pattern that the law was designed to address. And the question before this court is not whether Crestwood Property Holdings used offensive language or posted discriminatory signs or made statements of explicit bias. The question is whether their practices, taken as a whole, operated to deny people protected by federal law the equal right to housing on the basis of race. The answer to that question, on the evidence presented in this proceeding, is clearly yes.
I lukt at andre Simons.
I looked at his mother, who was sitting beside him in the gallery with her hands folded on the rail in front of her. And then I looked at Sterling Calloway, who was sitting very still at the plaintiff's table with an expression that was not what it had been when he walked into the room that morning. I issued my ruling. Andre Simmons had not committed an unlawful holdover. The termination of his lease was procedurally defective under Texas property law and substantively discriminatory under the Fair Housing Act. The claim for damages was dismissed. Crestwood Property Holdings was ordered to offer Andre Simmons immediate reinstatement of his lease on the original terms, to return his security deposit in full, and to pay documented relocation costs for the period of his unlawful displacement. I further ordered that the case record, including the demographic analysis and the deposition testimony from Crestwood's management team, be forwarded to the Civil Rights Division of the Texas Attorney General's Office for review of potential systemic violations at Crestwood Properties statewide. And then I addressed Sterling Calloway's citation directly, because I believe that what an attorney does in a courtroom is not just a professional matter. It is a matter of what the system is and what it does to the people who depend on it. I said, I am noting for the record the citation of Gordon v. Riverside Equity Management without acknowledgement of the controlling and bank clarification. I am forwarding this notation to the State Bar of Texas Grievance Committee for review. I am not prejudging the outcome of that review. What I am doing is ensuring that the record reflects what occurred and that the appropriate body has the opportunity to determine whether the representation made to this court was consistent with counsel's obligations under the Texas disciplinary rules of professional conduct. Sterling Calloway was looking at the table in front of him. I closed the hearing at 3:47 in the afternoon. I was putting on my coat in the anteroom when Robert Hensley knocked on the door. He said that someone was asking for me in the hallway outside the courtroom. I told him I would be out in a moment. The person in the hallway was Sterling Calloway. He was standing alone. His associate had gone ahead, and he had taken off his jacket and was holding it over one arm, and without it he looked younger and somehow smaller, the way people do when they remove the things they have put on to be seen a certain way. He looked like a man who had spent the last hour doing something internally that had cost him something. I would like to speak with you, he said. I looked at him. We can speak, I said. He was quiet for a moment. Then he said, I want you to know that I am aware of what happened in there with the citation. I am aware that I should have flagged the en-banc opinion. Yes, I said, you should have. He took a breath. I have been practicing for 16 years, he said, and I have never had a hearing go the way that one went today. I know, I said. He looked at me. I want to ask you something. And I want to ask it honestly, not as an attorney. I waited. When you walked into that courtroom this morning, he said, did you expect me to treat you the way I did when I first came in? I considered the question for a moment. Then I said, I expected you to make an assessment of the room based on what you saw and what you had prepared for, and I expected that assessment to be incorrect, and I expected to spend the morning correcting it. That is a version of what I expected, yes. He looked at the wall for a moment. The thing about the citation, he said slowly, the reason I cited it the way I did, it was not strategy. I genuinely did not know about the en-banc opinion. I have used that case before in this kind of argument, and it has never been challenged. I know that too, I said, because the judges who have heard it before did not catch it, I said, or did not prioritize catching it. Yes. He was quiet again. I think I have been practicing law, he said, in rooms where a certain kind of preparation is enough, where a certain kind of authority is enough. And I think I walked in here this morning expecting that to be true again, and it was not, and he stopped. I looked at him, and I thought about what I had said to Officer Mercer on Lancaster Avenue that morning, about making assumptions based on what the eye sees before the mind engages. I thought about what my grandmother had said about closed doors and learning how locks work. I thought about Andre Simmons on the floor of the hallway with his lease in his hands, and Dorothy Simmons driving across town at 10:30 at night. And what it costs a person to believe in a system long enough to keep trying to make it work. Mr. Calloway, I said, I am going to tell you something that I did not say inside that courtroom. Because inside that courtroom my role was to apply the law to the facts and not to editorialize. But out here I am just a person talking to another person, and I think it is worth saying. He was listening. The case you argued today, the one Crestwood hired you to argue, it was not a close case. The evidence of discriminatory practice was extensive and well documented, and it had been building across multiple properties for years. And Crestwood knew that. They are not a company that did not understand what their data showed. They are a company that looked at their data and made a decision about how much legal risk they were willing to take. Because they had calculated that the people they were doing this to did not have the resources to fight back. They hired you because they believed that resources and reputation and relationships would do what the facts could not do for them on their own. You were very good at your job. But you were asked to use those skills in service of something that was causing significant and documented harm to people who had done nothing wrong except exist in a body that certain systems have never fully protected.
He said.
Nothing for a long moment. I have taken cases, he said finally, over the course of my career, where I knew the outcome I was working toward was not the one that, he stopped again. I told myself it was the law, and that the law is neutral. The law is not neutral, I said. The law is a set of words written by people and applied by people, and it reflects the assumptions and the priorities of the people who write it and apply it. When it is good, it is because someone fought to make it reflect values worth fighting for. When it is bad, it is because those people were not present or were not heard or were not given the standing to make the argument. My job, and arguably yours, when it is done as it should be, is to be in the room and make the argument. The difference between us today is not ability. It is which argument we each chose to make. He looked at me for a long time. The referral to the grievance committee, he said. Is there anything? That is a matter for the committee, I said. I cannot speak to how they will receive it. What I can tell you is that the record accurately reflects what occurred. What you do with that, going forward, in terms of how you prepare and what you choose to argue and on whose behalf, is entirely within your control. He nodded. He put his jacket back on. I need you to understand something, I said. Not for the committee. Not for the record. For you. A young man spent 7 months out of his apartment, 7 months of his life disrupted, his studies affected, his sense of safety in the world damaged, because a company decided that the cost of harming him was acceptable. You were part of the structure that made that calculation feel safe for them. You do not have to be that going forward. You have 16 years of skill, and you have a name that opens doors. And those things can be pointed in a different direction. I am not telling you what to do with your career. I am telling you that you have more choices than you have been making. He said, I hear you. Then he said, thank you. Then he walked down the hallway toward the elevator, and I stood there for a moment watching him go, thinking about the distance between what he had said and what he had internalized, and knowing from long experience that those are rarely the same thing on the same day, and that the question of whether anything changes is always answered slowly, and almost never in a room where the conversation happens. I walked back out through the main doors of the courthouse. Andre Simmons and his mother were standing on the courthouse steps in the late afternoon light. She had her arm around him, and he had his head bent slightly toward hers, and they were talking in the quiet way of people who have been carrying something heavy for a long time and have just been told they can set it down. He looked up when he saw me. He straightened. He looked like he was going to say something formal, something prepared, and then he seemed to decide against it, and what came out instead was just, thank you. Really? I don't know how to say it bigger than that. You don't need to say it bigger, I said. What happened today is what was supposed to happen. You came to this process with the truth on your side, and the truth held up. I want you to know that is not always how it goes. There are cases exactly like yours where it does not go this way, and the people who lose those cases are not less deserving of the outcome you received today. The system is imperfect, and it is slow, and it is sometimes hostile to the very people it is supposed to serve. But today it worked. Hold on to that. Dorothy Simmons said, "Can I ask you something?" "Of course," I said. "How long have you been doing this?" 22 years, I said. She looked at me steadily. "Does it get easier?" Carrying the weight of it. I thought about that honestly. About Lancaster Avenue that morning, and 31 years of cases, and all the variations of the same closed door, and all the different keys I had tried to learn. "No," I said. "It does not get easier. You just get better at knowing why it is worth it." She nodded. She seemed to accept that as the true answer it was. I shook both of their hands and walked to my car. I sat behind the wheel for a few minutes, without starting the engine. The afternoon light was shifting, going warm and amber the way Fort Worth light does in the early evening in March, and the city outside the windshield had the look of a place that is simultaneously full of beauty and full of unresolved business, which is a description that I think applies to most places and most people if you look at them long enough. I thought about everything that had happened since 7:51 that morning. I thought about it not as a sequence of events, but as a single thing, as one continuous experience that had begun at a red light on Lancaster Avenue and ended on the steps of a courthouse, and that had, running through the middle of it like a thread, one question that I have been living with for 22 years and that I expect to be living with for as long as I continue to do this work. The question is not whether the system works. The system works sometimes. It worked today. The question is whether it works consistently, and for whom, and at what cost, and whether the people who are supposed to make it work are willing to do the difficult, unglamorous, often thankless labor of actually making it work for everyone instead of just for the people for whom it has always been easiest to make it work. I know the answer to that question. The answer is that some of them are and some of them are not, and the difference between those two kinds of people is not intelligence or ability or even good intentions. The difference is whether they have ever been asked, genuinely asked by a situation that required it, to see someone they did not expect to see in the place where they expected to see no one. Officer Mercer on Lancaster Avenue that morning had not expected to see what he saw. Sterling Calloway in Courtroom Four had not expected to see what he saw. And both of them, in different ways, through different paths, at different depths, had been shown something. Whether what they were shown will stay with them long enough to change anything, I cannot tell you. I have done this long enough to know that change is almost never immediate and almost never complete, and that the only way to find out if it happened is to keep watching, to keep showing up, to keep being present in the rooms where the assessments are made. That is what I do. It is what I have done for 22 years. It is what I will do tomorrow morning when I get up and get dressed and drive to whatever intersection or courtroom or legislative hearing is waiting. Because the work does not stop when the hearing ends, and the story is never really over, and there is always another Andre Simmons somewhere doing everything right and needing someone in the room who knows how the lock works. I started the car. I pulled out of the parking garage on Commerce Street and turned north on Throckmorton, and I drove home through the Fort Worth evening with the radio off and the city moving around me in the amber light. And I thought about my grandmother's photograph on the corner of my desk, and about what she said, and about the fact that 22 years in, the words still mean exactly what they meant the first time I heard them. The answer to a closed door is never to stand outside feeling sorry about it. Learn how locks work, and never stop. 3 days after the hearing, I received a letter. It was handwritten, on plain white paper, in the careful print of someone who had drafted it more than once. The envelope had no return address. The postmark was Fort Worth. I almost did not open it because I receive a great deal of mail, and some of it is unpleasant, and there is a particular category of envelope with no return address that a person in my field learns to approach with mild caution. But I opened it. It was from Travis Mercer. He wrote that he had been thinking about what I said on Lancaster Avenue for 3 days. He wrote that when he got back in his cruiser after I drove away that morning, he sat there for almost 10 minutes before he called in to dispatch. He wrote that he had replayed the stop in his mind several times and that each time he replayed it, he found something new to be uncomfortable about. He wrote that he had talked to his supervisor about bias training and had asked to be enrolled in the department's voluntary supplementary course, which had not previously been something he had sought out. He wrote that he did not fully understand yet why he had made the assumptions he made, but that he was trying to understand it, and that he thought the trying was something he owed not just to me but to everyone else he had ever stopped the way he had stopped me and who had not had what I had to show him. He did not ask for a response. He said he was writing because he felt he owed me an accounting, not an absolution, and that he understood those were different things. I sat at my desk for a long time after I read it. I thought about what it costs a person to write a letter like that. Not a great cost, some might say. A piece of paper, a stamp, 30 minutes of uncomfortable self-examination. But I have been doing this work long enough to know that the uncomfortable self-examination is the part that most people do not do, and that when someone does it and then chooses to document it and send it to the person in front of whom they failed, that is not nothing. That is the beginning of something. Whether it goes further or stops there, I cannot know. But the beginning is real. I wrote back. I wrote one paragraph. I told him that I received his letter and that I appreciated his honesty, and that the most important thing about what he had written was not the apology to me, but the intention to understand the pattern behind it. I told him that understanding a pattern is the first step toward interrupting one. And I told him that the people who would most benefit from whatever he learned from this experience were the ones he would never know by name, the people whose traffic stops he would conduct differently in the years ahead, who would go home that evening without the particular weight that I had carried on Lancaster Avenue, who would simply move through their day unimpeded because an officer made a different choice than he otherwise might have made. I told him that was worth something real. I sealed the envelope and put it in the outgoing mail. Then I opened my laptop and started reading the file for the next case. A month after the hearing, I received notice from the State Bar of Texas Grievance Committee that the matter involving the Gordon citation had been reviewed and that Sterling Calloway had been issued a formal admonition. The lowest level of disciplinary action, but a formal one, entered into the public record. His firm was also informed, which meant that the partners who oversaw his case selection and review process were now aware that a judge had flagged a question about the accuracy of a citation in a major hearing. I heard through channels. The legal community in Fort Worth is not large, and information moves through it with the particular efficiency of a place where most of the people who matter have known each other for decades. That Calloway, Brent, and Associates had quietly implemented a new internal review process for precedent citations in housing and civil rights cases. I also heard that Sterling Calloway had contacted the Texas Fair Housing Coalition. He had not contacted them to discuss a case he was working on. He had contacted them to ask whether they accepted pro bono work from private practitioners, and if so, what the process was for applying. I do not know what came of that inquiry. I do not know whether he followed through, or whether the initial contact was a gesture without consequence, or whether something larger began from it. Those are things that time will tell, and time tells them slowly, and I have learned to be patient with slowness when the alternative is expecting transformation to happen all at once, which it almost never does. What I know is that a man walked into a courtroom one morning believing that the room would work the way it always had for him, and it did not, and something in that experience reached him in a place that his preparation and his reputation and his father's name could not protect. Whether that reach went deep enough to take root, whether it grew into something that actually changed the way he practiced and what he chose to practice, and on whose behalf. That is a question I will not be able to answer with certainty. But I have spent 22 years planting things in rooms and waiting to see what grew, and I have learned that even partial growth, even imperfect change, even a person who moves 10 degrees in a better direction and stops there, even that has value. Even that shifts something in the landscape, however incrementally. The incrementalism is frustrating. I will not pretend otherwise. There are mornings when I think about how many times in 22 years I have had to prove my credibility in a room before I was allowed to use it. How many red lights on how many versions of Lancaster Avenue? How many Sterling Callaways in how many versions of that courtroom? How many Andre Simmonses sitting on hallway floors with their leases in their hands, doing everything right, waiting for someone in the system to see them clearly enough to help. Those mornings are real, and the frustration on those mornings is real. And I think it is important to say that because the temptation in stories like this one is to resolve everything cleanly. To suggest that the lesson was learned and the system corrected and the harm was fully repaired and everyone went home transformed. That is not what happened. Andre Simmons got his apartment back and his security deposit and his relocation costs. He also lost 7 months of his life to a displacement that should never have happened, and he carried through those 7 months a kind of uncertainty about whether the world was built to include him that I do not think one good hearing outcome fully repairs. Dorothy Simmons got to watch her son walk back into his life, with his head up. She also had one more experience to add to the archive of experiences she will draw on the next time she needs to explain to a room full of 8-year-olds why doing everything right does not always immediately produce the outcome that doing everything right is supposed to produce. That is a hard truth to hold and a harder one to teach, and the fact that she has been teaching it with grace and honesty for 31 years is one of the most remarkable things I encountered in this case. What I can say, what I believe to be true based on 22 years of evidence, is that every time the room works the way it is supposed to work, it matters. Every time a young man gets his apartment back instead of $22,000 in damages. Every time a citation is caught and flagged and placed in the record where it cannot be ignored. Every time an officer sits in his cruiser for 10 minutes thinking about what just happened instead of driving away and forgetting it. Every time a letter gets written and sent and answered. Those things matter, not because they fix everything, because they fix something, and because in a situation where everything cannot be fixed at once, fixing something is not consolation, it is the actual work. I have known that since I was 24 years old in my first real courtroom with a briefcase that was too big for me. I will know it for as long as I keep doing this. The week after the Simmons hearing, I was asked to speak at a continuing legal education seminar on Fair Housing Act enforcement, attended by about 60 attorneys from across the Fort Worth, Dallas corridor. Some of them were civil rights practitioners. Some of them were on the other side, defense attorneys who represented property management companies, developers, HOAs. I had agreed to do it because I believe that rooms where people talk across lines of professional interest are more valuable than rooms where everyone already agrees, even when those rooms are uncomfortable. I spoke for about 40 minutes. I talked about the statistical methods used to identify discriminatory patterns in housing decisions. I talked about the evidentiary standards under the Fair Housing Act in the Fifth Circuit. I talked about the 2020 Gordon N. Bank opinion, which I have found to be less well-known in the defense bar than it should be, and several attorneys in the room who were clearly hearing it for the first time made notes. At the end, during the question period, a man in the third row, a defense attorney, I could tell by the particular quality of the challenge in his question, which was careful and measured but pointed, asked me something that I want to share with you because my answer to it is the closest thing I have to a conclusion for everything I have told you today. He said, "Counselor, do you think the Fair Housing Act, as currently interpreted and enforced, is actually capable of producing the outcomes it was designed to produce? Or are we in a situation where the law is structurally insufficient to address the kind of systemic discrimination you're describing?" I looked at him for a moment. Then I said, "That is the right question, and I am going to give you an honest answer rather than a comfortable one. The Fair Housing Act as written is a powerful tool. As enforced, which is a separate matter entirely, it is inconsistent. The gap between the power of the words in the law and the power of the outcomes that law produces is filled by the people in the room. The judges who read the data carefully and the judges who do not. The attorneys who challenge the precedent and the attorneys who let it slide. The officers who sit in their cars for 10 minutes and the ones who do not. The property managers who ask whether their decisions are equitable and the ones who only ask whether they are defensible. Every single person in every single room where a housing decision is made, or a traffic stop is conducted, or a case is argued, or a letter is read. Every one of those people is either narrowing the gap between what the law says and what the law does, or they are widening it. There is no neutral position. The act of doing nothing, of letting things proceed as they have always proceeded, is itself a choice that has a direction. The question for every person in this room is simply, which direction are you choosing? And are you making that choice consciously, with full awareness of what it means for the people who will be affected by it? The room was quiet for a moment after that. Then people started writing things down. I took that as a good sign, not a sufficient one. Not a sign that everything was about to change, or that the work was nearly done, or that the gap was about to close on its own. Just a good sign. The beginning of a beginning, which, in my experience, is almost always how the most important things start. I drove home from that seminar on the same road where, a week earlier, a set of blue and red lights had come on behind me for no reason I had given anyone. I passed the intersection of Lancaster and Hemphill. The light was green. I drove through without stopping. Somewhere in the city, Travis Mercer was probably finishing his shift. Somewhere, Sterling Calloway was probably reading a brief for his next case, and maybe reading it a little differently than he had read briefs before. Somewhere, Andre Simmons was probably at his drafting table, or at the print shop, or walking home from a late class, carrying a key that worked, moving through the world with some of the same careful watchfulness he had always carried, but with something else alongside it now, some small but real piece of evidence that the system, when it actually works, can see him. And somewhere, Dorothy Simmons was probably grading papers, probably writing her small, encouraging comments in the margins, probably thinking about what she would say tomorrow to a room full of children who are learning, along with their fractions and their reading comprehension, something more fundamental, that the world is not always fair, but that you do not stop showing up and you do not stop expecting it to be, and you do not let the gap between what is and what should be convince you that what should be is not worth working toward. That is what I carry out of every room. That is what I will carry into the next one. That is, after 22 years, what I know for certain. The work is the answer. Not because the work always wins. Because the work is the only thing that ever changes anything, and because changing something imperfectly, slowly, incompletely, in the face of resistance and fatigue and all the versions of people like you that the world keeps inventing, is still, when it happens, worth every single day you showed up to try. Tomorrow, I have another case. There is always another case. And I will be there.